Sarah. Okay, thank you, Sarah. Hello, everyone, and welcome to today's webinar on hearing tips for SOAR practitioners. I just want to thank you for being patient. We have presenters from all over the country, so get everybody online was a little bit of a feat, but we have been successful. Today's webinar is presented by the SAMHSA SOAR Technical Assistance Center at Policy Research Associates under contract to the Substance Abuse and Mental Health Services Administration of the U.S. Department of Health and Human Services. My name is Pam Hine, Senior Project Associate with the SOAR TA Center, and I'll be moderating today's event. Before we officially begin the webinar, I would like to present Kristen Lutfer, our Project Director here at the SOAR TA Center, who will give our welcome this afternoon. Kristen.
Hello, everyone, and thank you again for joining the webinar today. We receive a lot of questions about assisting with SSI and SSDI appeals, and we're very excited that SAMHSA has made it possible for us to connect you with the experts in the field. Sarah Anderson, Jessica Cressman, and Beth Argent are going to do their real-life experiences and provide you with tools and tips that you can start using right away. So without further ado, let's begin.
Thanks, Kristen. Just a few housekeeping items before we begin. This webinar is being recorded and will be available for download on the SOAR website in about a week. Your lines will be muted throughout the webinar. Right now, you may download the PowerPoint slides and a few materials relating to the topic today. If you look to the top of your screen, you will see the File tab, then Save Document, and then the document to download the material. So you can definitely use that for the PowerPoint today and for future resources. At the conclusion of the webinar, you'll be directed to a link for an online evaluation. We value and appreciate your feedback and use it to improve and inform future SOAR webinars and activities. So we ask that you take a moment to complete it immediately following the webinar. So let's very briefly review our learning objectives and the agenda for today's webinar. On today's webinar, we have three presenters who have all represented SOAR applicants at the hearing level. After you listen to the presenters, we hope that you will understand a little bit more about SSA's hearing office called ODAR, Office of Disability Adjudication and Review, and understand some of their major activities, and know what is expected from the authorized rep when preparing for a hearing, Social Security disability claims, but also what is expected when conducting a hearing. So we really hope that you'll go away with a very basic understanding of preparing and conducting and what the ODAR office does. So we are very lucky to have, again, three representatives who have represented SOAR applicants at the hearing level. First, Sarah Anderson, who is a SOAR attorney at Greater Boston Legal Services, who will discuss preparation tips for SSA hearings in front of an ALJ, an administrative law judge. Next, we have Jessica Cressman, an attorney from Hell, Michigan, who has extensive experience conducting hearings. And rounding up presentations will be Beth Argent, who is a non-attorney representative in Columbia, South Carolina, and Beth will share her perspective on representing SOAR applicants. So before we begin today's presentation, we do want to start with a poll just to gauge your understanding of your level of participation in hearings. Okay. So what I'd like to ask is, how many ALJ hearings have you participated in? 5 or more than 5? So take a few seconds just to let us know your level of experience. I'll close the poll in about a second. The majority have had no experience. So I think that this webinar will be right up your alley, and whether you would like to do hearings, you will have some the information that you need to get started, but then also know how you can continue your education with preparing for hearings. So thank you very much for your participation in this poll. So now I'd like to hand the mic over to Sarah Anderson, who will begin her presentation. We're just on mute a second.
Let me say I'm really delighted to be here this afternoon, and welcome to everybody who's participating in this. I have the greatest respect for all the work that SOAR has done, and that's really by practitioners such as yourselves through the years. This afternoon, I'm going to give you an overview of what we call the Office of Disability Adjudication and Review, and then give you some sense of what happens before the hearing is held. Remember, it can take up to a year to get a in-person hearing, so that's a lot of time to go by, but you can certainly use all of it. Looking for how to change the...
Just at the top of your screen, you'll see the number 8. We're on slide 8, so the arrow to the right of that to advance your slides.
Sorry, where is it?
To the right of the number 8 on the top of the PowerPoint slide. See a number 8. We can only advance the slides for you, Sarah.
Yeah, oh, I see. I'm sorry, I'm looking in the wrong place. Okay. All right, I'm all set now. Thanks for that tip, Pam. The Office of Disability Adjudication Review, as it's known, also goes by acronym ODAR. So you may hear that as well. It is one of the divisions of the Social Security Administration, and they have a nationwide corps of administrative law judges who hear the cases de novo. De novo means for the first time. It's a Latin term. That indicates that they are looking to see in the first instance, does the individual meet the disability standard? And so they use they take a look at what's happened in the initial and reconsideration stages, but they're quite able to make up their own minds, even based on the same evidence that's been submitted at our initial or reconsideration. ODAR holds hearings, it issues decisions, and it reviews appeals. This afternoon, we're really only going to be speaking of the hearing offices, and we are not going to the administrative law judge hearings are held. We are not going to be talking about the appeals council. That's the final stage of administrative review. It's a paper review, and that office is located in Falls Church, Virginia. There are 10 regional offices, 168 hearing offices, 5 national hearing centers, national case assistance centers. To give you some idea of the scope of ODAR's work, there's over 1,300 ALJs who issue over 700,000 decisions annually. Not all of them, but most of those would be on the for disability cases. The hearings offices may also hear somebody's benefits are being terminated. They have a slightly different standard for that. It could be an SSI case. It could be whether somebody's getting the correct payment amount. It could be an overpayment case. But as I said, we're really focusing on the work they do this afternoon with just the disabilities. Okay. The overview of the hearing is that an individual who has filed a claim for SSI or SSDI disability benefits has an absolute right to appeal a denial or if their benefits are being terminated, they have the right to appeal. The appeal must be filed within 60 days of receipt of the denial of reconsideration. And again, just to review, you have the initial application. If you're denied at that point, you have the right to request reconsideration, which is again reviewed by the DDS agency in your state. And finally, you get to the ALJ stage. There is limited late filing for good cause. Good cause could be something like the client is homeless and they never got the reconsideration denial. It could be that the client was in the hospital at the time and missed the deadline for that reason. But it generally has to be something of that nature, and you would generally have to submit evidence. You'd have to prove, essentially, why the individual had missed that deadline. So the tip is just try not to miss it. Pay attention to it. If you've already signed on as the representative, then you should be getting a copy of the reconsideration. In this case, it would be a denial notice. So if you file an appeal, how do you actually go ahead and do this? There's several ways that this can actually be done. The first is there is something that is called iAppeal, and that is what Social Security calls its online appeal system. And if you just go to their website or you Google SSA iAppeal, you will find it, and they do give you sort of detailed instructions on what to do. The point that you need to pay attention to here is that there are 3 forms that need to be filed to essentially what we would call perfect your appeal or make sure that it's timely filed. The first is that last form I have listed on the slide, HA 501. That's just a 1-page appeal form, and the client or you have to fill it out. There's a paragraph that you can include as to why you're filing the appeal. You don't really need to say very much in there. You don't need to go into the fact that the client feels that that SSA totally missed all the evidence. This is a system of what's called notice appealing. All the client has to say is, I am disabled and I cannot work, or I disagree with the reconsideration denial. At that stage, all you're doing is letting Social Security know that you want to file an appeal. The second form is what's called the SSA 827, and that is simply their authorization to release information. If you're using the iAppeal system, there's something called the online click and sign system, so you even have to have the client's sort of wet signature. The SSA 341, you may be familiar with this form. It's the disability report, only for appeals, and this is an important form to complete. They want to make sure that you get everything that you can in there. If the client has gone to the doctor recently, if you think their condition has changed, put that in. It's a fairly detailed form, and it's very similar to the disability questionnaire or report that would have been filled out both initial stages and at reconsideration. If you are seeking attorney's fees, and this may not be for SOAR folks, it may apply more to attorneys, then you are required to use the iAppeal system. Other than that, claimants and representatives have a choice of how to file the appeal. The forms that are listed, the 41, the 827, the 501, they can simply be mailed in to the district office. They could be hand-delivered. Or the client or you can call the 800 number of the district office and say, I wish to file an appeal, I need help. So, for example, if you find that you don't know if you're going to represent the client at the administrative law judge stage yet, but you see that the appeal the time is going to run in a week, send the client into the district office and tell them to file the appeal on their own. You really want to make a very good effort to get that appeal form timely filed. If you don't, it just sets everything back. One tip would be when you see the date of denial of the reconsideration form, let's say it says January 1st, 2015, your deadline would be 60 days after that date. You may not get it. It may take them 10 days to mail it out, another 5 days for the client to pick it up. Also would extend the appeal time. But in fact, if you can get it in within 60 days of the date of the notice, as opposed to date of receipt, I think that's a good habit to get into, and then you don't run into any of the problems with getting the appeal in. What happens next? Once the appeal is received, the ODAR hearing office sends an acknowledgement of receipt of the hearing request. It will go to the claimant at whatever address they put on that hearing request form, and if you have signed on as the representative, you will get a copy yourself. It may just be a one-page form. In some instances, it can run up to 20 pages because they will be asking you for updated medical and vocational information. In some instances, ODAR will look at the record and they'll see, gee, this hasn't been updated for 6 months or possibly longer, and then they will send out their forms to you, to the individual, to the client, and ask for those to be returned to the hearing office. If you are going to be doing hearings regularly, and I suppose even if you're not, one good tip is really to introduce yourself to the hearing office. Go over there, call them up if they're close to where you are working. But just let them know who you are and what you're going to be doing. Remember, there's 168 offices nationally, and I guarantee you each one does things just a little differently, and it's very useful to find out what's happening with your own local office. One of the first things that will happen is that scheduling of the hearing. Actually, it's not one of the first things, but something that you should know about that is that it is up to the individual ALJ. And so in a hearing office, there could be anywhere from hearing officers and a small one till, possibly, in Boston they have maybe 14. I'm sure in other very large ones, such as in New York, they could have, twice that number of ALJs. But typically, the individual ALJ, once they are assigned to the case, controls how the hearing goes. One of the things that will happen, even before it's assigned to an ALJ, is that you have to make a decision as to whether you want to proceed or would agree to a VTC hearing. That means a video teleconferencing hearing. If they've changed their rules in the last year, last September, October, and they gave a little more leeway to the hearing offices in setting up these hearings. So what it means is if a claimant is going to object to a hearing by video, you have to do so within 30 days of the notice that one may be scheduled. And that notice would typically go out early in the process. There may even be such a notice in that initial notice that you get from the hearing office. So one thing that you want to make sure you do is read everything that's in that hearing office notice and then read it again and figure out what it is that you need to do, and pay attention to whether there's a whether there's mention of a VTC VTC hearing. And that's a decision that you and your client are going to have to make. And what it means is that the administrative law judge and the claimant are not going to be in the same hearing room, will not be seeing each other face-to-face. They'll be seeing each other over video. Now, here in the Boston office, and I'm just using this as an example because it's the one I'm familiar with, and we typically would object to holding a hearing by video conference. And because it's a relatively small office and it's very close to us, we're pretty much guaranteed an in-person hearing. That may not be the case if your hearing office is, you've got only one or two hearing offices and you're in the state of Utah or Wyoming or Montana, or, you know, you could be, your client could live, 200 miles or 500 miles from the closest hearing office. And at that point, you're going to have to weigh, do I want to go for a video hearing? It may be quicker, or do I really feel that it's important for the judge to see my client in person? So I'm not going to say too much more about that. I just wanted to highlight that so that people would be aware of it, and it's something that you're going to have to think about. Again, if you miss the deadline and they schedule a video hearing and you want to object at that point, there are, again, limited good cause reasons for doing so. As with any administrative agency, they have the rules, they have their objections, and then they usually give you, an opportunity to say, change their mind. But the threshold, I think, is fairly high. The other thing that we could see more of would be telephonic hearings. Now, that may happen, for example, that has been given is for prisoners. In some instances, in the past, ALJs have gone actually and done administrative hearings in the jail. Not all jails have that capacity. Some do. And some ALJs are willing to travel to prisons or jails to do those hearings. It's possible those could now be done by telephone. And again, when you sort of think about it, you have to outweigh the convenience factor and the quick factor with, if this is the first time that a judge or a decision maker is seeing my client, do I really want to do it over the telephone? So that's something that you will need to kind of think about. As I mentioned, I think it can take up to a year, if not longer, to get an in-person hearing. This varies dramatically by hearing office. And so you are really going to need to check what's the average amount of time in your particular hearing office that takes to get one to either get a hearing or to get a decision. That would be talk to other people in your area who go to that hearing office. There are some statistics online, and Social Security does keep some records with respect to the amount of time that it takes a case to go through the hearing office. But in that fact, remember that you have strategies either to get a quicker hearing or a quicker decision. There's on-record decisions, and I think SOAR has done a webinar on those. Again, you can go ahead and present all your information in writing to the judge. You have a particular kind of case that would qualify as a compassionate allowance. Social Security has a very long list. If you have a client who has an impairment that sort of meets to the letter the definition of a compassionate allowance, you may be able to get you should be able to get actually a quick decision. care cases. Those are for terminal illness. Dire need. Those are ones where, you know, you provide a reason to the judge that a client has dire need. Simply being on the state welfare program won't do it. Being homeless in and of itself will not qualify one, at least in the judges where I've made that argument to get a dire need hearing. But maybe certain other circumstances. Is the client going to be, is their house going to be foreclosed on? And it looks like they have a very strong case. That would be, you know, an example of where dire need. There's a list of things in the regulations and also in the HALEX which qualify for the dire need. Basically, in any of those, again, you're going to have to make the case to the ALJ, and typically in writing, as to why your case is dire need, why the judge should issue a compassionate allowance, why the case should be approved on the record. So again, you have to be prepared. Don't just sort of say in 2 lines, Judge, I'm requesting that you issue an on-the-record decision in this. Remember, when you're being an advocate, particularly at this level, you are expected to point out in detail, you know, why you think your client's going to prevail. So if you have 400 pages of medical records that Exhibit 12F and you're citing to them, don't just give a cite to Exhibit 12F. Give it to Exhibit 12F, page 32 to 37, if those are the specific things that you are relying on. Let's see, pre-hearing conferences. This is another thing that you need to pay attention to right off the bat. You find out, does your particular hearing office or ALJ use these? And these are exactly what they sound like. They are in-person conferences. Occasionally they've been done over the telephone, and they really serve 2 purposes. Some offices may use them if there is no appointed representative on file at the hearings office. And they then call the individual in and just tell them that they're entitled to have a representative if that's what they want. Try to find out if there's any updated medical evidence. Talk to the claimant about that. Try to get some information. And it's really designed to not have a case sit around for a year or, you know, 10 months with nothing happening on it. And so that's one of the things that they do. In some instances, individual ALJs, administrative law judges, may use a pre-hearing conference with representatives. And there, again, the theory is that they want to narrow the issues in the case. They want to find out, is the onset date, you know, still what you're alleging, particularly in a Title II case? Are there additional medical evidence? He may ask what the theory of the case is. To know about the pre-hearing conferences, and this would be included on the notice that goes out with them. The notice of the pre-hearing conference that goes out is that if the claim doesn't show up, then when it comes time to hold the hearing, and if the claimant does, the judge may dismiss the case before the hearing itself is held. So there are consequences, and so if you see a client who's got one of these pre-hearing notices, even if you're not representing them, urge them to go to that pre-hearing conference by themselves. Make sure that they follow up on that paperwork. Another thing to do early on after the hearing request is filed is you want to get a copy of the record that ODAR is using after the hearing has been filed. And Most disability cases now have electronic records as opposed to paper records of the claim. And so you may have seen that when you've done cases at initial and at reconsideration stage. That simply continues on up through the administrative law judge stage. There are various parts of the electronic record. There is something that's called the exhibit list. That is actually the document that becomes the sort of official record of the administrative law judge hearing. And if you have to file the appeal, either to the appeals council or even on up to federal court, those are the documents that will be reviewed by whatever appellate body is conducting the review. That's called the exhibit list, and you may have seen them. These are usually prepared by the hearing office staff about the same time the hearing notice goes out. And so do you have to wait till the exhibit list is assembled in order to get a copy of the record at ODAR? The answer is no. You should be able to get one as soon as you know that you are representing the claimant. The other form is simply called the case documents list, and that has essentially every piece of paper about that particular claim that Social Security Administration has entered into the record. So, for example, that will include medical records, but it also includes the requests that DDS has sent out for the records. Typically, the requests that DDS sends out don't end up in the exhibit list. They're just part of that case documents, or what used to be called a raw file. Parts A, B, D, E, F, those are just sort of how Social Security has organized the electronic file. You typically don't see those divided into parts, I don't think, when you're doing a case at reconsideration. There is a hearing, either a pre-hearing conference held at the hearings office, or hearings itself. There's a CD that is made of it. It is recorded electronically, and those become part of the file that anyone can listen to, or else they become part of the file that is reviewed by either the appeals council or the federal district court. If in the case you're doing it at the hearing itself, and you see that there was a pre-hearing conference that was held, you should be able to get the audio tape of it. You may have to request that specifically, but the hearings offices should provide them. So you can either get the CD from the claimant, they will typically send one out to the claimant, or you can get one from the hearing office staff. You should just be aware that they are encrypted, and so you need to sort of get the rules for opening the encrypted file, and then you also need to know that there are certain programs that you need on your own computer in order to be able to read the file. Typically, when you are filing any papers, it could be the claimant has already filed a request for a hearing and you're getting involved after that's happening. If you know it's an electronic file, you want to file this electronically. In order to do so, you need what's called a barcode from ODAR. You cannot use the barcode that you may have seen or was used at DDS for either initial or reconsideration. The separate part of the agency all have their own barcodes. Some registered representatives, often attorneys, can upload files directly to claimant's electronic record. That's a very convenient way to do it, and it's a little beyond the scope of this afternoon to discuss that in detail, but you should just be aware of that. Again, you should pay attention to the fact that there is a deadline for filing evidence before the hearing. So once you get the hearing notice, the minimum amount in some places, if you haven't made an arrangement for the hearing, it may only be 20 days. In Region 1, the New England states that are listed on the slide, they have more restricted evidence rules, and so they are required to submit all evidence of at least 5 business days before the date of the hearing. That doesn't include weekends, doesn't include holidays. And certainly, if you're not in Region 1, think about it. It's probably a pretty good idea to get all the evidence submitted even before the 5 business days. I've heard, certainly some experienced attorneys who will say they make every effort to get all their paperwork, all the evidence, and a memorandum into the hearing office 10 days before the hearing. And the reason for that is if you want the judge to look at the material that you're submitting and you have it available to you, I'm not talking about documents that you submit at the last minute. That certainly does happen. If you submit 500 pages of medical records the day before the hearing, the judge is not going to have the opportunity to look at it before hearing. So help your client out, help yourself out, and submit evidence in advance, and then submit electronically. You can then check with the hearing office to see that they got it, but certainly it's worth doing. Social Security is required to provide an interpreter if somebody is of limited English proficiency. It could be that they speak English as a second language, or it could be ASL, but it is their responsibility to provide an interpreter for the hearing. In some instances, it's quite clear from the record that the claimant doesn't speak English. There have been previous notices, for example, that have been sent out in Spanish, or there is something that calls the attention to the hearing office staff that an interpreter is needed. But make the request yourself. Follow up. Don't depend on the hearing office to do it, because it does make a difference. So then, once you get the CD, what you need to do is you need to review what is on that file. What is missing for the evidence? It could be personal information about the client. They don't have anything about their children. They don't have anything about their education. It could be medical. You look at it and you see that information that you thought that you had sent for reconsideration never made it into the hearing file. Well, that would be something that you would know that you would want to submit. Vocational. Social Security is certainly going to be looking at what is the individual's vocational profile. There are, in fact, earnings records that are in both the case documents and the exhibit list, and so you may be called summary earnings record. It may be called certified earnings records, but be sure to open those, because they will tell you when Social Security thinks your client's last worked, and it will tell you what jobs the client has paid FICA taxes on. Now, if something has happened in the last 6 months or the last year, it may not be included there. But, you may have a claim that's going back 7 or 8 years, and your client told you that they hadn't worked in 10, and then you find out that from this that they earned $10,000 in 2014. So you look at that beforehand. That will give you the opportunity to discuss with your client, what is this about? because I can guarantee that when you get to the hearing, the judge will ask you about that. Part of what you need to know is what do you have to do to prove to get benefits. The disability standard is the same for SSI and SSD, but remember you have SSD, it's an insurance program. You have to know when the client is alleging they were disabled. It's called the onset date, and you also have to know when were the date last insured. Because it's an insurance program, you have to show that they were disabled prior to that date. SI, again, it's needs-based programs, so what you're concerned about is really the date of applications. When did the client apply for benefits? You also should be developing your theory of the case. That's for your own information, and it will help you develop the information that you need. But it's also something that you're going to be presenting to the judge, either in writing or at the hearing itself. And if you just think of it as a few sentences as Susie Jones is disabled because, and then want to fill in 2 or 3 sentences what happens. You know, I've heard it described as an elevator speech. You know, if you were going up in an elevator with the judge, you know, and you're going up 5 floors, what could you say what would tell them about your case? What's your theory? And once you have your theory of the case, you can then go back and you figure out, oh, I think the client meets listing 12.04, but I don't have enough information to show that they have marked impairments in activities of daily living. I've got to get that. Or I don't have enough to show that they have, you know, all the elements of Part A of that particular listing. Again, you also need to think about when you're doing a hearing, am I going to get that information through live testimony or through written records? And again, I think that if it's something that your client knows about, you're going to want to go ahead and you probably need to have live testimony. That can be particularly true with respect to subjective symptom pain or fatigue. Information about diagnoses typically comes in writing. We have discussed it's the first time the claimant meets the decision maker face-to-face. You've paired your written statement, and you also will need to do prepare your claimant or witness other witnesses practice session. Run through it. About what they have to do. And write a memo to the ALJ. Tell them in detail why your client's disabled. Again, cite to specific records. Tell the ALJ of the theory of your case. And again, pay attention to deadlines for submitting evidence. Don't miss them. Finally, learn about your ALJ. You can find out information by talking to other people who practice in that hearing office, or you can find out some online statistics. A couple more items before I wrap up. SAA has published a new evidence rule. This is one of the handouts for SOAR and for SOAR programs, and I think they did a terrific job, so I'm going to direct you to that handout. But you should just know that it does apply to you, even though you're not attorneys, if you're a representative, and that it is an attempt by Social Security to clarify evidence submission in disability cases. So the rule that they've clarified is that you are required to inform or submit all elements to a claim for disability. That does include unfavorable medical opinion letters or unfavorable evidence. Our exceptions, attorney-client privilege, that would be a conversation that you would be having with a client, a work product. That could be a conversation that you would be having with the treating physician. these rules apply both to non-attorneys and attorneys as well, even though they're just they come from an attorney-client rules, and so that's why they're referred to as the attorney-client privilege. But they do apply to non-attorneys, and the representatives may be sanctioned. So pay attention to those rules. Authorized representative, I'm just going to conclude with this. You must submit the signed 1696 form. I'm sure you're familiar with that. Both you and the claimant have to sign it, and that you should be aware that SSA has rules of conduct for representatives, who can be a representative, the authority, prohibitive conduct, and sanctions. So with that, I'm going to conclude my part and turn it over to Pam.
Thank you, Sarah, so much. You've covered a lot of ground, provided some great resources. And you're discussing before the hearing even starts. So we're going to turn it over to Jessica Kresnit, who will talk a little bit about conducting an ALJ hearing. Jessica, the floor is yours.
Thank you. Oh.
You are.
Thank you. I'm really happy to be presenting today. I know that my first hearing was a little bit scary, so I'm really glad that SOAR is providing this for all of you here. So to start with, I know that Sarah touched on this a little bit, and I thought it was really important to stress a little bit more, because the day of the hearing, you will really regret it if you didn't get to know more about your ALJ. You're going to know whether they allow witnesses or whether they prefer written statements or affidavits from witnesses. If you plan on bringing witnesses, you want to let them know ahead of time. Because if you show up with witnesses and your judge doesn't allow them, they're going to go on the hearing. So you're also going to want to know whether or not he or she allows evidence to be submitted on the day of the hearing. Even if you're not in Region 1, as Sarah was talking about, the judge may not allow you to submit evidence the day of the hearing. They're going to want to have all that evidence in front of them when you're presenting your case to the judge. You're going to know how they conduct their hearings, and you want to know their statistics. And you can go to the website. It's www.disabilityjudges.com, where you can find out the percentage of your judges' dismissals, their approvals, their denials. And you'll also see some comments that other people have written. Sometimes they're comments by attorneys, sometimes they're comments by claimants, which sometimes I would say take that with a grain of salt. But you may find out some things about a judge, like that they prefer you to dress professionally, or something of that nature. So on the day of the hearing, I recommend that you dress professionally, whether you're an attorney or you're not. I recommend a business suit or a blazer and ties for males. And there are different schools of thought on whether or not your client should dress up, dress their best, versus dressing as they dress every day. And I would discuss that with your client, and maybe when you've looked at your AA's background, you can determine with your client how that should be handled. Arrive early, and client know to arrive early. You want to be there at least an hour in advance so you can secure a conference room. If there is not a conference room available and you'd like to discuss with your client the case, and you respect any issues of confidentiality. Remind your client of the points of his or her testimony, and remind the client what to expect during the hearing. If your client cannot make it to the hearing, call your ODAR office. Your ALJ might require you to show up in order to show good cause to adjourn and reschedule. And the good cause is similar to what Sarah was talking about. Missed the deadline for filing the appointment. So you might have to show that your client was in the hospital, or that your client, I guess generally had good cause to miss that hearing. And then to review the file closely before the hearing. While during that time that you're meeting with your client, you may have access to a computer where you can review your encrypted CD and ensure that all of the submissions are included in the file. Mark copies of the exhibits that you submit after received the file, and alert the judge if you have any objections to what's in the file. The hearing itself is non-adversarial, which means that there's no opposing counsel at the hearing. It's small and informal, and it's not good by the federal rules of evidence. However, you must comply with the courtroom decorum, and it's to the public, so it's not like a courtroom where anybody can walk in. Audio recorders and microphones at the hearing. Adding the people that will be present are, for sure, are the ALJ, the reporter who is taking notes during the hearing, documenting everything that's said. There's the claimant, and there's the representative, which would be you. There will also be a hearing assistant, interpreter, and two options of expert witnesses. There could be a medical expert and or a vocational expert, and they're requested by the judge. And I'll talk a little bit more about what those are. In your interaction with the judge, the hearing is informal, but you still want to address the judge as Your Honor or Judge. Keep a respectful tone, and to ensure that the record reflects your best argument. Also means if you're conducting a hearing via teleconference or video, you want to make sure that things are documented. Now, I have experience with teleconference. You want to make sure if the client is crying or if the client reaches for a Kleenex, that's reflected in your testimony. You say, they say let the record reflect that the client is reaching for a tissue. Let the record reflect that it is shaking. Necessary, assist your client if he or she is unable to appropriately respond to the judge. For example, if the client has several hospitalizations but they can't remember the name of the hospital or the time that they were hospitalized, you can point to an exhibit and of the exhibit that they were hospitalized at St. Mary's from June 19, 2012 to July 4th, 2012. That's different than testimony, but generally if the client is not responding well, you can assist as long as you are able to point to specific exhibits in response to the judge's inquiry. You can't testify on behalf of the client. If you wish to testify on behalf of the client, then you need to withdraw as a representative to provide evidence. Hearing, the claimant and the representative will sit in front of the ALJ with microphones in front of them on the desk. The judge will, they may be sitting on a bench or maybe at the same level. The judge will introduce all parties that are present and ask the representative to make an appearance. The representative, for example, I would say, my name is Jessica Krefman on behalf of, and I would state my name. Also state that I am an attorney representative or that I am not a non-attorney representative. The judge then asks the claimant to take an oath and swear to the truthfulness of his or her testimony. At that time, the expert witness would also be asked to take an oath. Judge would then introduce the case and the claimant. They would say this hearing concerns the claimant's application of June 4th, 2014 for supplemental security income, and they may go into more detail about the case. The judge would address all exhibits in the record and ask for any additional exhibits. These are then made part of the administrative record. The judge may also ask if there are any additions to the record or if there are any objections. For example, something that you might object to is if there are somebody else's records ended up in your client's case. The ALJ may take testimony from the claimant. Depending on the judge, representative may make a brief opening statement that sets forth the basis of for finding the claimant disabled. So they briefly discuss the work history, the date of onset, and when the claimant stopped working. But the judge may have already introduced all this information, so it may not be necessary. There's a pre-hearing memo that was submitted, which sometimes can be the medical summary report if it's already been, the initial application was a SOAR case, although I like to pare that down a little bit to create the that can be referred to. You have a chance to question your client, question the witnesses, and cross-examine any expert witnesses. And some judges will allow the representative to start the initial examination of the claimant. In most of the hearings that I've been in, and I don't know if this is true for all regions, but the judge starts with the examination of the claimant and then allows the representative to examine them themselves. Some may begin by asking questions, and there may not be any questions left for the representative to ask. The claimant should be prepared to effectively respond to all the inquiries at the hearing and be aware of any issues that may be brought up during the hearing. For example, if your client has applied in the past for unemployment insurance, it might conflict with their application for disability insurance, and you want to be aware and be prepared for your client to answer those tough questions. A representative should develop a series of questions pertinent to the case prior to the hearing date. And if the judge is asking questions, I usually go down my list and cross off any questions that I had that are duplicates. You want to give questions towards the case. So if the client has a mental impairment, the question should be geared towards the mental impairment. Some cases, the theory of the case may be helped by testimony from other witnesses. For example, family members, friends, caseworkers, former employers, coworkers, or relevant persons. We are, many of us are SOAR workers and therefore may or may not be case managers. For you to determine before the case whether it would be more effective for you to be a witness as opposed to a representative. These witnesses must be specifically prepared prior to the hearing. So you'll want to meet with them in advance and know what their testimony is going to be. If ALJ doesn't allow witnesses at the hearing, you want to provide some signed affidavits from the relevant witnesses. Expert witnesses, and I told you I'd get back to these. These are at the request of the ALJ, so they are there to give the ALJ a little bit more information about things that the expert may not fully understand. That the ALJ may not fully understand. A medical expert is a doctor or a psychologist, and the testimony is based on the record and the testimony at the hearing. So they will be prepared to talk about the record. The complicated medical issues to the judge, including the level of severity of the claimant's impairment and whether the judge or the claimant meets or equals the listings. A vocational expert is trained in vocational rehabilitation. The ALJ will usually ask a series of hypothetical questions based on your claimant's past relevant work, level of skills required to complete the job, and exertion levels. An example of a hypothetical question that a judge might ask is, assume a man 35 years old with 10th grade level education, employed as a landscaper for 8 years, requires breaks every 15 minutes for 5 minutes at a time, and lifting is limited to no more than 10 pounds. He requires only minimal contact with the public, needs verbal direction from supervisors, and will miss work days out of the month. Are jobs in the national economy that this man can still do? And the vocational expert would tell the judge yes or no. Yes, they would list the jobs and how many jobs in the national economy exist, or in the local economy. So if the judge may explain rationale behind their hypothetical, so they may say that they can only this hypothetical person minute breaks because they have COPD or something like that. They may not explain the rationale, and therefore that would give you the responsibility to claimant or the judge to point out your claimant does fall under that hypothetical. If the judge, if the vocational expert does say yes, there are additional jobs in the national economy, the judge asks further questions. The judge may continue to ask hypotheticals until the vocational expert says no, there are no jobs in the national economy under those conditions. The judge completes their series of hypotheticals or they're questions to the medical examiner, then it's your turn to cross-examine the expert witness. As far as cross-examining the medical expert, I want to ask follow-up questions. And a medical expert has not asked about certain strong evidence, then you want to ask about that evidence. You want them to define the disability terms like moderate limitations. You'll want to make sure that they understand the definition of those terms. If the medical expert's testimony is favorable, then you don't want to ask any follow-up questions. Vocational experts, cross-examining vocational experts. You'll have your own hypothetical questions prepared in follow-up to the judge's questions. However, if the ALJ's hypothetical leads the vocational expert to conclude that there are no jobs in the national economy, you want to ask any further questions. But direct questions towards the judge or your client if you need clarification on the rationale for the judge's hypothetical. You want to then give a closing statement only when it's unclear, when there's unclear or unresolved legal issues that arise during the hearing. At least use it only when there's resolved issues. After testimony is complete, you'll highlight the important evidence that supports your case. Judges occasionally state in the hearing whether they will award your case, but most often they'll end without announcing a decision, and you'll have to wait until the written decision to you by mail. At that time, you'll receive a notice of decision, which is either fully favorable, partially favorable, or favorable. So, partially favorable means that may mean that the judge is changing the date of onset or something like that. That will also be sent with the decision of the judge. The decision will include the procedural history, the law itself, any findings of the judge, conclusions of the judge, and then the decision. It requests more time to submit evidence at the hearing. The ALJ will keep the record open, possibly for 2 weeks. Most judges follow must follow the judge's strict deadline. So if they say 2 weeks, your final evidence must be submitted within 2 weeks, or the case may be dismissed. ALJ may order a consultative examination following the hearing, and the claimant has to attend it as it's scheduled. If the claimant is denied, then the claimant has the opportunity to appeal. They must do so within 6 days of the ALJ's denial. The Appeals Council then reviews the administrative record and determines whether they will dismiss the appeal. And if they dismiss the appeal, then the claimant has 60 days to file for judicial review with the U.S. District Court. Or they can grant the appeal, and they can either reverse the findings or can remand it to for an ALJ hearing to new judge. So, recommendation to anybody who is starting out and hasn't done any hearings, or even if you have done some hearings and you just want some additional information, find local disability attorneys. You can turn to legal aid or services. You can turn to pro bono attorneys or Disability Benefits Coalition. You can attend mock hearings, and a good source for mock hearings might be YouTube. There are plenty of mock hearings on YouTube. So the National Organization of Social Security Claimants Representatives, and continuing education for attorneys and non-attorneys, as well as training for people who present disability payments for disability benefits. And finally, I think it's very important to have a contact at the local Office of Disability Adjudication and Review. Have somebody you can reach out to who can let you know about little changes, or let you know about specific judges' preferences. So thank you, and I will put on to the next person.
Thank you so much, Jessica. Now you can take a breath. Again, a lot of information, great resources that Jessica provided. We have time to listen to our last presenter, last but not least, Beth Argent from Columbia, South Carolina, who's going to give the non-attorney perspective. Beth, go ahead.
Okay, this is Beth Argent from Columbia, South Carolina. I work at a small nonprofit called Mercy, the Mental Illness Recovery Center. What I do there is I am the SOAR case manager, the benefits specialist, and the bulk of what I do is doing initial SOAR apps, but also other hat at Mercy is I'm a homeless outreach worker, so I work out of the local shelters, but also on the streets, and I assist folks on the streets with doing SOAR applications, but also sort of had my hand in assisting these folks with doing a few ALJ hearings. So I want to kind of give my perspective about being an advocate for a SOAR client at an ALJ hearing as a non-attorney representative, but also using like the SOAR key components to aid in a hearing, because I'll tell you that MSR, that medical summary report, it's really useful in those initial SOAR applications, but it's just as useful in those ALJ hearings. So I'm a SOAR case manager, not a lawyer, and there may come a time as a case manager that you find yourself assisting a client with an ALJ case. And I know you're thinking, I'm a SOAR case worker, I'm not an attorney, and we do follow the same rules. Non-attorney representatives follow the same rules that attorneys do. And we do not provide client testimony. We prepare the client to provide their own testimony, but we can certainly be an advocate for them. And it sounds really scary and overwhelming, but actually I think a SOAR caseworker can be a very super useful and effective non-attorney representative for this population. You're not an attorney, but being an advocate for a client, especially someone who's experiencing homelessness and someone who's experiencing severe mental illness, going to the hearing with them, helping them prepare, that's much, much better than them going into an ALJ hearing unassisted. It's important to note that as an advocate, you don't testify on the client's behalf. I know that was something, my first ALJ hearing, that I was very sort of concerned about. I thought, I was very about, am I going to have to testify? I've only known this client for a few months, but no, use them for their testimony. And I would say, you do a lot of preparation in the front end. So submitting medical records ahead of time so the judge can have a chance to review them. And just like the previous ladies were talking about, 7 days, 10 days, really the earlier you can get them in, that's, much more time that the judge can review those records. And I had twice where judges have approved clients on the spot at the hearing because I was able to write a really, thorough medical summary report, submit all those medical records, way in advance. And the judge, literally pulled me in, asked me a couple questions, pulled the client in. I think he may have had a question about some previous drug use, and approved her right on the spot. And that has happened a previous time as well. So that's just a big plus about submitting all that evidence beforehand. And it's successful in the record review using that same method as well. So really, the earlier you can submit evidence and the more thorough your evidence can be, that's just great. But, you know, in that case, for the on-the-record review, I had submitted copious amounts of evidence. I had really tied all of that evidence together in a really thorough medical summary report. I got the client's treating psychiatrist to sign off on it, so it was considered medical evidence. And I also included a note to ask them to look at it beforehand. And just a few weeks later, I'd gotten a call from the ODAR office saying, you know, they approved my client on the record, didn't even need a hearing, and all they wanted to do was talk to her to, you know, possibly amend the onset date. So those SOAR key components can really help you advocate for a client. You know, the 1696, so you can represent the client and advocate for them. Gathering the medical evidence, and you know, a lot of times these SOAR clients, if they're transient, if they've been homeless, if they've had a severe mental illness, a lot of times they might have those spotty medical records. So it's really good to kind of sit down with them and take the time and really try to find out where they may have been treated. So you can really try to submit as thorough case for them as you can. And also submitting a signed medical summary report. If you get, you know, signed by their treating psychiatrist, that really just their case quite a bit. And also being a non-attorney representative, you know, you can also offer moral support for your client, you know, getting to the hearing beforehand, you know, 30 minutes to an hour beforehand, and really sitting with your client and kind of talking them through it. It really helps. And also, I'm kind of a position where I'm able to take my clients and provide transportation to the hearing office. So I always ensure that they're, you know, able to have transportation to and from the hearing. As an attorney representative for a client experiencing homelessness and mental illness, you can advocate for this unique, often misunderstood population and help tell their story through testimony and effective cross-examination skills. Advocate building a rapport with the client can really allow you the opportunity to do some digging. You can dig their past hospitalizations and medical history, their job history, you know, really start to learn who they are as a person. You know, maybe there's some past trauma, you know, things might have shaped their present circumstances. Individuals who've experienced long-term homelessness, you guys know they have a very layered history. There are lots of events that have contributed to their present circumstances, and a lot of events would be useful for the ALJ to know. You know, gain the client's trust, hearing story, it can allow you to gather those details to a really strong medical summary report that highlights story and really emphasizes that they're a human being, you know, not just medical records. And really having the time to sort of sit down with the client and dig into their history can reveal some very interesting things. For example, had a client from the shelter last October. He had a scheduled ALJ a hearing right around the corner. One of those like billboard attorneys that just less than reputable reputation in the community. So he wanted to fire his attorney, and so he did. And I was, you know, I told him that if he wanted me to, that I would help assist him with his hearing. So I got him to sign a 1696. Sat down, started to prepare for his hearing, and he told me that he used to receive benefits as a child, and then he continued to receive them as a child, and then they stopped in like 2012 for no reason. And I thought that was really interesting. I did some digging, found out that he was still entitled to benefits as a disabled adult child, and they had went away in 2012 when he started working full-time, and he never told Social Security that he had been fired from his job. So he could have been entitled to these, you know, continue to be entitled to these disabled adult child benefits for like 2 years, but no idea. So I called my contact at Social Security. We found out that he could totally forego a hearing, get reinstated for benefits, and that they would pay him back those 2 years that he should have been getting those disabled adult child benefits. So just sitting down and hearing his history, I was able to do some digging, and we were able to completely just forego a hearing and get him, a favorable outcome.
That is just a wonderful way to end our webinar. Your zealous advocacy has really done so much for your clients. In fact, Beth had her first video hearing last week and was awarded with a bench decision right on the spot. So, Beth, great that you're doing. With that, we have time to take a couple of questions that came in, but I want to just reassure everyone that if we weren't able to get to your question, we will put them together in an FAQ and attach them to the webinar on our website, and be sure to connect you to our wonderful presenters if these questions were specifically intended for our presenters. So let's take one question. The question is there a test or certification to represent with our advocates? Is there a test? Beth, would you like to take that question?
Absolutely. No, you can completely be non-attorney representative without taking any kind of test. Now, you can't receive any kind of back pay. You're not entitled to any kind of back pay for your services or any fees for your services. There is some national test that they do once a year for non-attorney representatives who are eligible for back pay, and that Social Security they contract that test out to some company. But you can be an attorney representative. You could be somebody's caseworker and be a non-attorney representative. You're just not eligible for any sort of fees for your services.
I answered the question. I have another question here. If filing the appeal, are all forms with part of the I-appeal available online? I'm going to see if Sarah can take that question. Are the appeal documents available online for the I-appeal?
Yes, all the appeal documents are available online.
Great. That is all the time we have for questions. I just want to again take this time to thank our presenters who have all been very busy with hearings over the last couple of weeks. So again, just a quick reminder to please complete the brief online evaluation of today's webinar. And for more information on the topic, please visit the SOAR website at www.soar.prainc.com. And to contact the SOAR TA Center by email, soar@prainc.com, or by phone, area code 518-439-7415. We'll be sure to direct any questions or comments which could not be answered today to our presenters for their responses. And thank you so much, and have a great rest of the day.